Welcome, everyone, to this month's webinar, Working with Parkinson's. My name is Donna Greening, and I'm a Programs and Services Coordinator at Parkinson Canada. Before we begin, I have just a few housekeeping items. From coast to coast, we acknowledge the ancestral and unceded territories of Inuit, Métis, and First Nations peoples. We have enabled closed captioning for the benefit of attendees who may be hearing impaired. You can turn on or off closed captioning on your own screen by clicking on the CC Live Transcript button and then clicking on Show Subtitle or Hide Subtitle. Please note that this feature uses auto transcription, so there might be some spelling errors along the way. At the bottom of your screen, you'll see Q&A and chat buttons. Later on in the webinar, we will have a few minutes to have some of your questions, including ones that were submitted when you registered, answered. So if you have a question, be sure to write it in the Q&A window. The chat window is there for you to say hello and talk amongst yourselves. Before we start, we're going to screen a short message from our President and CEO, Dr. Karen Lee.
Over 100,000 Canadians live with Parkinson's. We have one of the highest rates in the world. My name is Karen Lee. I'm the CEO of Parkinson Canada. My late grandfather lived with Parkinson's disease, and I know very well the importance of family and how they have to come together to support one another, but most importantly, the person living with Parkinson's. That is why I am dedicated and committed to ensuring Parkinson Canada continues to empower those living with Parkinson's. Each year, our programs and services reach over 10,000 people. We are a community. We are here not only for the person living with Parkinson's, but their family, friends, and their care network to ensure we all continue to thrive. Our advocacy efforts are focused on raising the voices of people affected by Parkinson's. Our Parkinson Advisory Council is made up of people affected by Parkinson's from across the country. They bring a diverse background and experience, but most importantly, they provide me and the organization with advice on topics that are important to them and their community. As a scientist, I know the importance of investing in bold and novel ideas that lead to breakthrough discoveries. At the same time, bringing researchers, clinicians, and people living with Parkinson's to collaborate to push the needle in our understanding of Parkinson's disease. We invest in the next generation of researchers and clinicians to ensure that we continuously understand the Parkinson's disease and also the care management of people affected by Parkinson's. When I'm in the community, I want people to know that Parkinson Canada is with them in every step of their journey with Parkinson's disease. People often ask, when is the right time to connect with Parkinson Canada? Is it when they have their first diagnosis? Is it when their symptoms get worse? Or is it when they need more information and resources? The answer is now. Researchers and clinicians are working tirelessly to find a cure. Meanwhile, every single day, 25 more Canadians are diagnosed with Parkinson's. Our goal is to empower people affected by Parkinson's to live well now.
Now, let's get started. Leanne Goldstein owns MK Disability Lawyers LLP, which specializes in advocating for individuals with disabilities and disability claims. Leanne has been a lawyer for 20 years. 16 of them were spent advocating for individuals whose short-term and long-term disability benefits were wrongfully denied by insurance companies. She has extensive experience litigating disability cases against every disability insurer that offers disability benefits in Ontario and has litigated several cases against U.S. disability insurers. Prior to her admittance into the Law Society of Ontario in 2002, she practiced personal injury litigation and represented individuals denied disability benefits. In her spare time, Leanne advocates for children with special needs and devotes her energy to volunteering for disability-related charitable causes. Leanne volunteers her services pro bono for community legal clinics and mentors lawyers who are beginning their journey in the legal field. Welcome, Leanne.
Thank you so much, Donna Greening, Larry Linton, and Parkinson Canada for inviting me to speak this evening. I have, over the past 20 years, represented many individuals with Parkinson's disease who have litigated against insurance companies for denying or terminating their long-term disability benefits claims. The individuals that seek my assistance are often at an earlier stage of their diagnosis. Some may have been diagnosed with early onset Parkinson's disease or have yet to receive a Parkinson's diagnosis, but are still undergoing investigations. Typically, these disability claims are denied or terminated because symptoms are not considered significant enough in the eyes of the insurance company to meet the tests for disability under the insurance policy. Invisible symptoms like cognitive changes, fatigue, and mental health issues, which often accompany the diagnosis, are frequently misinterpreted, downplayed, or disregarded by insurance companies. I'm also often consulted by individuals who are contemplating a disability claim, which leads to conversations about the timing of a disability claim and questions about how one can remain working for as long as possible before having to submit a claim for disability benefits. This leads me to the agenda for this evening. We're first going to talk about what are your rights as an individual with an illness or disability. What duty is owed by your employer? How is that duty activated? What are your obligations as an employee and what strategies can be employed? What is the impact of disclosing your medical condition? And finally, what to consider when making a claim for disability benefits. At the international, federal, provincial, and territorial levels, there are protections available for individuals with disabilities. At the international level, Canada has ratified 7 principal human rights conventions and covenants, including the Convention on the Rights of Persons with Disabilities, which protects the right to equality and non-discrimination of individuals with disabilities. The Canadian Charter of Rights and Freedoms is part of the Canadian Constitution and guarantees equality rights in Section 15. The Canadian Human Rights Act protects Canadians from discrimination when they are employed by or receive services from the government and federally regulated entities. On a provincial or territorial level, human rights laws are similar to the Canadian Human Rights Act, and they're also designed to protect people from discrimination in areas of provincial and territorial jurisdiction. And that might be in relation to restaurants, stores, schools, housing, and most importantly for us, workplaces. Many provinces and territories have human rights commissions, which are creatures of statute and are designed to carry out functions under the applicable provincial or territorial human rights legislation. Part of the mandate of the human rights commissions is to resolve complaints through human rights tribunals. So if you believe that you have experienced discrimination on the basis of disability, you could potentially file an application with the appropriate human rights tribunal in your province or territory. So in Ontario, for example, the Human Rights Tribunal of Ontario is tasked with resolving claims of discrimination and harassment brought under the Ontario Human Rights Code. And in some provinces like Ontario, there may be a legal support center that assists individuals with the application process. Human rights legislation is designed to protect employees from discrimination at work, including disability-based discrimination. So when an employee is unable to perform their job or aspects of their job due to a disabling condition, the employer has a duty to accommodate that employee. The duty of accommodation requires the employer to modify work rules, work practices, and policies in order to meet the needs of individual employees with disabilities. In other words, employers are required to remove barriers that could limit, restrict, or prevent individuals with disabilities from fully participating equally in the workforce. If an employer fails or refuses to accommodate the employee, there are some remedies that are available. And these will often depend on whether or not you are a unionized or not a unionized employee. If you are a unionized employee, your remedies may lie in the grievance and arbitration process. If you are not unionized, you could look to, as we indicated earlier, filing a human rights claim through the human rights tribunals, federal or provincial, depending on your circumstances, or alternatively, you might be able to proceed through litigation and the court system, depending on the circumstances of your situation. Now, the next question that arises is, how far does the employer's duty to accommodate extend? An employer is required to accommodate to the point of what we call undue hardship. And that is a legal term that has been established through various cases that have proceeded through various jurisdictions. It is a fairly extensive obligation that requires employers to take extra steps in order to promote a fully integrated workplace. There is no specific guideline as to what constitutes undue hardship, and it really depends on essentially the circumstances of the employer and the employee. Undue hardship essentially exists when the steps that are required to accommodate the employee are seen as so extreme or so onerous or so difficult that it would be deemed to be unreasonable to expect the employer to implement them. In the process of accommodating an employee, the employer is required to gather information, to consult with the individual, to create a specific plan to eliminate discrimination, and always to ensure confidentiality. It's interesting to note that in essence, accommodation duties can be triggered either where the employee makes an express request for accommodations, or sometimes where the employer realizes that there may be a situation or a need for accommodation. The employer needs to consider various factors and conduct a balancing test by looking both at the perspective of the employer and the employee when considering whether something would constitute undue hardship in the accommodation process. And some of the factors that might be considered would be financial cost, whether there are safety issues, whether there might be an impact on other employees. Undue hardship will vary greatly depending on the nature and size and financial means of the employer. There are many examples of accommodations, and again, they are situation dependent, but some examples might include a graduated return to work after a leave of absence, allowing an employee to work from home, allowing for flexible work hours, for example, to attend medical appointments or investigations, part-time work to accommodate fatigue or cognitive impairments, physically modifying the work environment using ergonomic assessments, changing job tasks to make them less onerous, incorporating assistive devices and technology, things like talk-to-text, speech recognition software, closed captioning, and so on. Accommodation is a two-way obligation. As an employee, you have an obligation to cooperate with the employer in the accommodation process. And this involves communicating to the employer the need for accommodation, providing relevant and appropriate medical information to support the request for accommodation. It means essentially considering options presented by the employer. And this is important because Rejecting reasonable accommodations proposed by the employer could potentially impact an assessment of whether or not the employer has met its legal obligations to accommodate you. And you're also obliged to inform an employer if the measures that the employer has put in place need to be changed in any way. So if your needs increase, or if your needs decrease, or if your needs change, that is something that should be in an ongoing communication with the employer so that the employer can modify those accommodations as time goes by. In order to trigger accommodations, it makes sense then that there has to be some form of disclosure of your medical condition. And obviously associated with disclosure, there are some pros and cons. So I've listed some of the pros and cons, and I'm sure there's many more that we can think of. But some of the pros or positive elements of disclosing medical information would be to activate the human rights protections that we've discussed earlier. Disclosure could potentially lessen the likelihood of an employment termination because the employer may have a better understanding of your limitations and the need to accommodate you. It may provide an explanation for variability in an employee's productivity. So there may be a rationale for why an employee is productive at certain moments in time or less productive at other moments in time. And this will provide the employer with an explanation. It may also enable you as an employee to perform more effectively because you're modifying your work requirements to meet your restrictions and limitations. For instance, working at times when you are more productive, which might be outside of work hours. Despite the fact that you do so, you may still be able to get the work done. Some of the cons or negatives of disclosing medical information could be the stigma associated with doing so. You might face questions regarding your competence or ability to perform your job. These might be questions that are expressed to you. Alternatively, they might not be questions that are expressed, but they might be something that your employer or colleagues might be looking out for. You could potentially be targeted by the employer or by colleagues and set up for termination. Obviously, there are emotional impacts associated with disclosing medical information and disclosing diagnoses. You may also not be afforded equal opportunities, which is potentially a risk of disclosure. Again, it comes down to a balancing act, and in understanding disclosure, it's also important to know how much information actually needs to be disclosed, particularly in the context of seeking accommodations. So an employee seeking accommodations should only disclose the general nature of their disability and any restrictions and limitations sufficient to allow the employer to properly accommodate them or to determine the legitimacy of a requested leave of absence. It is really important to know that employees have the right of privacy regarding their medical information, and an employer does not have the right to full disclosure of an employee's medical situation. An employer should always make an effort to ensure that there is the maximum amount of medical privacy available when determining accommodations. Most of the time, it's actually not required for you to provide an actual diagnosis to the employer. As long as you can provide your restrictions and limitations and enough information to enable the accommodations to be put into place, it is not necessary for you to go into the details of your diagnosis in any significance. Sometimes, despite all the accommodations that have been put into place, you might still be unable to work. And it might be at that moment in time where you give some consideration to the possibility of applying for disability benefits, assuming that these are available to you in the course of your employment. And most often they are. So just to distinguish between different types of disability benefits, short-term disability benefits are usually available for shorter periods of absence. They're designed to cover short-term illness or injuries with a shorter recovery period. Long-term disability benefits are obviously for longer periods of absence, and that is why there's typically something called an elimination period or a waiting period built into most disability plans or policies. So in order to access the disability benefits, you have to be continuously disabled during the waiting period or elimination period, but you will not start to receive benefits until the end of that period. Typically, specifically in relation to group disability, there's some variations when we discuss individual disability applications, but typically the application consists of a claimant statement, an employer statement, and an attending physician statement. The claimant statement is prepared by the person who completes the claim, and it usually asks for biographical details, name, address, date of birth, details about last day worked, details about disabling conditions, information about treating doctors and specialists. The employer statement is completed by the employer, usually confirms employment, last day work, nature of conditions, nature of occupation, and details of pre-disability income. And an attending physician statement is part of the application process that is completed by healthcare professionals. Now, the question really becomes, do I qualify for disability benefits, and how do I know if I qualify? And this is a very lengthy discussion and, is something that's beyond what we're here to discuss, but just some key notes and tips. Usually the initial disability test will require the person to be disabled from performing their own occupation. Usually that's a 24-month test. After that, the test changes to, is the individual able to perform any occupation based on their education, training, and experience? There might be a gainful component to that. In individual policies, you might be dealing with an own occupation rider, which modifies the definition of disability. Claims under the any occupation definition typically involve an analysis of a claimant's employability. And often, as I indicated, there is the question of whether or not a prospective alternate occupation is gainful. Many people believe that they're not disabled enough to apply for disability benefits. And unfortunately, insurance companies perpetuate the myth that in order to apply for disability benefits, you essentially have to be completely bedridden. This is not accurate. And in fact, the leading case on this issue actually provides a very different perspective from what most people expect. And I've actually listed the test on this slide, and it essentially says the test of total disability is satisfied when the circumstances are such that a reasonable man would recognize that he should not engage in certain activity, even though he literally is not physically unable to do so. In other words, total disability does not mean absolute physical inability to transact any business pertaining to one's own occupation, but rather that there is a total disability if the insured's injuries or illness are such that common care and prudence require him to desist from his business or occupation in order to effectuate a cure. So you can see from that test and that definition of disability that it is not a scenario of being required to be completely incapacitated. The question really is, in a workplace context, what are the functional limitations that you have that prevent you from being able to perform your occupation? So there is no list of prescribed conditions that qualify for disability benefits coverage. And again, the question becomes, does your medical condition or the symptoms that you're experiencing in relation to your medical condition impact your ability to function in the workplace? A couple of tips to bear in mind when you're completing forms: make sure that all information relevant to your medical issues is provided. Include as much medical information as possible so that the insurance company has a full picture of your medical issues, functional restrictions and limitations that are preventing you from working, and explain why those functional limitations and restrictions prevent you from working in your specific workplace or occupation, or in any occupation. Remember that communicating with an insurer is very different from communicating with your employer. When you're communicating with your employer, as we indicated earlier, due to privacy reasons, you're not necessarily required to provide detailed accounts of your medical issues. The same does not apply for communications with your insurance company. Providing the insurance company with more extensive information can often facilitate the approval of a claim. It's also important to include supportive medical records with the application forms. There's a mistaken belief that you're only limited to providing the claim forms, but in fact, the likelihood of an initial approval of benefits is enhanced if you submit supportive medical reports in the first instance. Things to consider: Equal weight should be given to your physical, cognitive, and fatigue issues. As indicated, focus on functional restrictions and limitations. Continuity of treatment is persuasive. Credibility and perception of disability is important, and this is particularly so in what we call invisible disabilities. So when you're dealing with things like cognitive impairments or fatigue, we commonly refer to those as invisible disabilities because they can't be seen through an X-ray or a blood test or anything like that. But of course, they can be just as debilitating as something that can be seen through an X-ray or a blood test. And that brings me to something that is particularly important, and that is the timing of a disability claim. If you are making a disability claim, it is important to ensure that your timing is appropriate. And this is something that has to be evaluated in some detail. And, I would always consider every scenario to be based on its specific facts. But one thing to consider is if, for example, you have reduced your hours and you're working on a part-time basis because you have tried to continue working, bear in mind that this could potentially impact the income used to calculate your disability benefit entitlement, whether you're dealing with a group disability benefits claim or an individual claim. So the timing of your disability claim can be very important. Not all disability claims are approved. So if your claim is denied, you have a couple of options. You can appeal. You can also litigate against an insurance company that has denied or terminated benefits. If you've made a claim for disability benefits or you are being accommodated by your employer, you might be curious as to whether or not your employment can be terminated by your employer. Many people mistakenly believe that making a claim for disability benefits and being on a leave of absence or being accommodated automatically protects them from a termination of their employment. That's not necessarily accurate. Employers are entitled to terminate employees without cause, provided that the employee is either given notice or payment in lieu of notice. And some examples might include, the employers generally restructuring their business, there's insufficient work, and so on. So it is not uncommon for employers, in fact, to terminate employees on disability as part of a general restructuring process. Fortunately, sometimes this is an easy way for employers to disguise the termination of an employee on disability as a legitimate termination as part of the general restructuring process. If a company obviously is going through organizational changes and a termination forms part of the overall restructuring process, it may not be wrongful or discriminatory, provided that the employer has offered appropriate severance as required by law and the decision to terminate was not motivated in any way by disability. But there are other circumstances and scenarios that exist where termination of an employee who's on a disability leave or is being accommodated can be deemed to be both wrongful and discriminatory. You might have been told, for example, by your employer that you're being terminated for just cause. And to support this termination, your employer might be relying on instances of poor performance, such as frequent absenteeism or lack of communication with the employer. So, it's important to understand that proving termination on the basis of just cause is a very high threshold for an employer to meet. If your conduct in the workplace is in any way due to medical issues, your employer will have a very hard time supporting a just cause termination. So if your employment was terminated for any reason directly related to your disability, there's a strong possibility that the termination could be considered a human rights violation. And it's important to examine every termination to see whether or not that element exists. Even if the decision to terminate was based in part on a prohibited ground such as disability, it could be found to breach human rights legislation. Again, another important thing to bear in mind is to prove that your termination was based in whole or in part on a disability. You must establish that your employer knew you were dealing with medical problems, which again brings us back to the issue of disclosure and the importance of it. It's also not unusual for employers to terminate employment when disability claims are terminated because they believe, based on what the insurer is telling them, that the employee is no longer disabled. They may believe that the employer is no longer legitimately off work due to medical reasons, and this may result in an employment termination. So if your employment is terminated when you are on disability or you are being accommodated by your employer, again, you have some recourse. If you are a unionized employee, you can look to the grievance and arbitration process. If you are a non-unionized employee, you can look to litigation potentially for wrongful dismissal and human rights violations. And you might be able to look to the Human Rights Tribunal, for instance, if the employer has stopped accommodating you and in essence, your employment has been terminated. And at the end of the day, I think what I say to all my clients who ask me about returning to work and accommodations is it's really important to ask for what you need and to communicate with your employer. It's also really important as human beings for us to have a meaningful aspects to our lives where, for instance, if we find joy in our jobs, if we enjoy our careers, that we try to remain engaged in them for as long as possible, using the tools of accommodation and knowing your rights so that you can ensure that you can attain that goal for as long as possible. Thank you so much.
Thank you so much, Leanne, for providing us with such great information. There certainly is a lot to consider regarding disclosures and how workplaces can make accommodations for people with Parkinson's. We are now going to hear from Larry Linton, followed by Susan Fullerton, who will each share a bit about their own experiences working with Parkinson's. Larry Linton was diagnosed with Parkinson's in 2012. After stepping away briefly from a successful 30-year career in law, he re-entered the workforce in a new role that not only accommodates his symptoms, but builds on the new abilities he has developed over the past 10 years while living with Parkinson's. In the spring of 2021, Larry stepped into the role of Parkinson Canada's Parkinson Advisory or PAC chair, and then transitioned to serving on Parkinson Canada's board of directors in June of 2022. He is the Amazon best-selling author of Shaken, Not Stirred, Living with Parkinson's Disease. His firsthand perspective on life with Parkinson's shares learnings, life lessons, and personal wisdom. His philosophy is that being diagnosed with a chronic, progressive, and incurable disease may not signal the beginning of the end, but may in fact be the start of a more rewarding, fulfilling, and meaningful life. Susan Fullerton was born in Halifax and grew up in Nova Scotia. She obtained a BA in music before going to Dalhousie Law School. After graduating in 1990, she moved to Toronto and has spent over 30 years working for the Ministry of the Attorney General. After first being diagnosed with Gaucher's disease in October 2016, she was diagnosed with Parkinson's in April 2017. In 2021, she was one of 4 patients who participated in phase 1 of a clinical study that used focused ultrasound to open the blood-brain barrier to administer therapeutics, and hopes to participate in phase 2 of the study later this year. An avid traveler pre-COVID, Susan has been to 6 of the 7 continents and is completing the list by visiting Antarctica this fall. Welcome, Larry and Susan.
Thank you. Thank you, Donna, for that introduction, and thank you, Leanne, for that great presentation. Disclosure and accommodation, 2 of my favorite topics. I'd like to say a few words from a lived perspective. As is often the case when we have Parkinson's, we tend to live against Parkinson's. We deny what we have, we deflect, we disengage, and we withdraw until we reach the point of acceptance and when we can start living again. And the same is true of working with Parkinson's. In my case, following my diagnosis, I withdrew from my team. I buried myself in my office. I disengaged from team events and client meetings until I reached the point of acceptance in that regard as well. It took me about 2 years to get to the point where my life with Parkinson's on my medication was being well controlled. And that's when I felt confident to disclose to my team what I had. And that brought a sense of relief. both to them and to me. They knew what I had, but felt relieved that I had disclosed that I had this condition. So I managed to rearrange my schedule. And despite the condition, which as we know is chronic and progressive, my career still progressed. I managed to get through a partnership process and had good years. So my decision to disclose was at a time where I was in control of my condition. But when the condition started taking control of me, that's when I withdrew and took some time to write a book and spend some time looking after myself. But over the period between 2019 and last year, I started missing corporate. I started thinking that, could I work? Could I engage? Could I contribute? And what happened was that I had an opportunity to join a firm, and I thought long and hard about that. And I looked in the mirror and basically realized that I had to perform at a different level. I was not the same person. I was not that same partner. So at the opportunity in 2021, I had the approach from a former colleague to join his practice. But I realized that I wouldn't be able to function at that high level. So I adopted a accommodation test on my own. What I did is I listed all of my duties and responsibilities that I performed over the following year or the preceding years, and isolated what I could no longer do, but more importantly, listed the duties that I could perform. And it sort of developed into a job description and a position, because then I knew that I could do what I had listed cognitively, responsibly, and that's when I accepted the position. But in addition to that accommodation exercise, I made sure that I had a schedule of my work hours. I surrounded myself with a team that was and is supportive, and also with the adaptive technologies, that Leanne mentioned. Like, I don't use a mouse, I use a trackpad. And these are small examples where we can use our open disclosure and open accommodation discussions with an employer, and find that employer who is willing to invest and support and encourage us so that we can continue to contribute and add and be a person and willing and able to contribute and work. So disclosure and accommodation are two favorite words, but in my case, it worked well for me. And I'm looking forward to hearing from Susan about what her lived experience is all about. Thank you.
Thank you, Larry. So I had a bit of a different journey. I think I've been very lucky in the sense that I was diagnosed very early. I know a number of people have Parkinson's or Parkinson's symptoms for many years before they're diagnosed. And because of the genetic disorder I had, I was diagnosed very early in my Parkinson's life. I'm not very good at keeping secrets, and I'm pretty much an open book. I'm sometimes considered an oversharer. And so when I was first diagnosed, I actually stopped at the stoplight, left the hospital, stopped at the stoplight, had a little cry, and went back to work. I recognize that's probably now a bit of denial, but my boss was away and I have a responsible job and I felt the need to go back to work. When the person that I reported to came back, I told her I had Parkinson's. So it was very, very soon after I was diagnosed that I disclosed at least to the deputy that I worked for. And not long after that, I reported directly to the public guardian trustee, the head of the organization that I worked for. I did that in part because I was on a job track for succession planning, and I was concerned about the impact of the disease. I wanted to be clear with him that maybe I might not be able to get the job that I was in line for next. Fortunately for me, my employer has been incredibly supportive. And he is unbelievably considerate to me. And I've been, as I say, I've been very, very lucky. So when my immediate supervisor retired, I did get the promotion that I was expecting to get. And the office has been very accommodating to me over the past 4 years. So gradually I became more open with other people in my office, colleagues, staff, and I'm still working full time. I attribute that to the fact that I was able to trust my employer. I've been there for over 30 years. So they knew my work ethic. They knew who I was. I think they knew I was being open and honest with them. And so they've been very supportive. I've had some of the types of accommodation I've had have been that I worked from home all the way through COVID, and I've continued to work from home on occasion as need be. We're gradually doing a return to work in my office, but there's been some discussion about whether I need to be in the office as much as everybody else. I got a small laptop, a Surface, which was lighter and easier for me to carry than everybody else. When I went back after post-COVID and we were gradually returning back to the office, I got another laptop in my office so that I don't actually have to carry my laptop back and forth. So I'm on the Surface at home when I'm working from home, and I have a standard laptop in the office. Perhaps most important to me is Donna mentioned that I participated in a phase 1 clinical study. It was pretty significant in terms of time commitment. There were lots of meetings, lots of appointments, pre-testing. It went on from the summer of 2020 until about February 2021. I fell and broke my tibia, so that sort of extended the time frame of my clinical study. But there were times that I had to cancel meetings. I thought I was going to have the procedure in October because I had the accident. It got postponed until January. So there were chunks of time that I was just saying to my team, I may not be available because I was being at the mercy of when appointments were available and when the procedure was going to start. And once the procedure started, for the 4 weeks that I was involved, I wasn't in the office very much at all, because I was in the hospital for a couple of days for a week, and then I was back in the next week for another day or two for tests, and then the procedure again. And so it was a fair commitment for my employer to be able to say, we're okay with you working basically part-time during that time period. I've also benefited from flexible work hours. So again, I was listening to Leanne's presentation with the recognition that I've benefited from my employer's ability to accommodate my needs. I'm looking forward to participating in phase 2 of the study. I've already talked to my employer about it, and they're committed to supporting me through that. So I feel, again, I feel like I've been quite lucky. I will say that, as I said, I think I said this, but I just want to say it. It was really important to me to know that I trusted the people that I was disclosing to. So I knew that I was safe in doing that. I've certainly heard some stories about people who've not had the same kind of experience, but for me, I knew I was comfortable disclosing at an early stage because I trusted that they would do the right thing and that there would be no issue with my ability to be accommodated as need be. Thank you.
Well, thank you so much, Larry and Susan. Susan, I know you said that you benefited from your employers being so accommodating, and I must say that you're for both you and Larry, that your employers also benefited from having you on their teams and being able to contribute your tremendous skill. Having Parkinson's doesn't mean you don't have those skills anymore. It just means you might have to use them a little bit differently. So at this time, we're going to answer some questions. If you've got any that you didn't submit before the before registering for the webinar, feel free to put them in the Q&A tab. We're going to go to a couple of questions that were submitted. So the first one is for Leanne. Someone asked, when the time comes, should I reduce my hours of work or go on sick leave?
So I think every answer from a lawyer starts with the words, it depends. And I think it really depends on largely what your doctors feel are perhaps, the most appropriate things for you in the circumstances. There are some individuals who have essentially reached a stage where functionally they are struggling and they would not be able to continue to perform the duties of their job, even with appropriate accommodations. And so what might happen in a situation like that is, even if you reduce your work hours, you might still be struggling in the workplace. And again, that could give rise to all sorts of complications for you. In certain workplaces, it could result in errors that may have detrimental consequences. You might have situations where it could be detrimental to your health if you continue to work and you don't go on a disability leave. In what I mentioned earlier was also the risk with respect to if you continue to work and your hours continue to be reduced over time. When you get to the point where you do have to make a claim for disability, you might be in a situation where your income has dissipated to such a significant extent that you don't have that necessary income protection. But there are also obviously circumstances where individuals can potentially reduce their hours without it significantly impacting either their income or their ability to function or their well-being. So again, one should be guided by your medical professionals, as well as looking at the specific circumstances that you're contending with in relation to what both Susan and Larry have mentioned, the willingness of your employer to accommodate, the willingness of your employer to assist you to continue to work. And again, every situation is individual and should really be sort of scrutinized from the ground up and considered in the context of your specific situation.
Great, thank you so much. Now, this question is for both Larry and Susan, so maybe we'll get Susan to answer first. What have you found to be the biggest challenge and reward to still working while having Parkinson's? Susan?
Okay, sorry. So I thought this was a great question. For me, I think the biggest challenge has been the inconsistencies of my disease and not knowing how I was going to be one day from the next. Yesterday I had a presentation that involved a number of staff, and I was really nervous unexpectedly, and I was quite twitchy with my Parkinson's, and I'm not often feel that way during the day. So you just never know from one day to the next what's going to impact you. And I would say sometimes I've sent emails that I shouldn't have sent because I've moved kind of unexpectedly. So I would say that would be the biggest challenge, a little bit of embarrassment there on occasion. For me, the biggest reward it's twofold. One, I still feel like I'm making a difference. The day after I sent an embarrassing email last week, my boss asked me to write something, and he was very, very happy with the work that I did. So made me feel good. But the other piece for me is I've become a little bit of a face of Parkinson's in my organization. We have a federated health campaign across the province, and last year I shared my story and it got a lot of interest, and I felt like I was sort of sharing the word of what working with Parkinson's could look like. So that's a pretty big reward for me.
Great. How about you, Larry?
My biggest challenge is the fact that we live with this chronic progressive disease, as Susan has mentioned. From day to day, we may have challenges, but I think in the work environment, the biggest challenge that I faced was the question whether or not I could work and what I couldn't do, and I found that a challenge. But on the flip side of that, a challenge becomes the reward, because I faced that challenge and took on a job knowing that I wasn't going to be functioning at that high level, but in a comfort zone of an operational level, which I'm comfortable with, and I am able to monitor my symptoms and still feel productive. So that's what life with Parkinson's is all about, a challenge and a reward. And I think if you get the balance right with a interested and caring and authentic employer, we can all feel that we can still contribute.
Great, thank you. Here's another question for Leanne. Does long-term disability coverage generally end at age 65?
Yes, it does. There are some rare occasions in the group disability world where it might extend beyond, but that is extremely rare. However, if you have an individual disability policy, there might be circumstances where it could extend into perhaps age 70 if you have a rider that specifically addresses that issue. But for the most part, most group disability policies, meaning the policy that you have through your employer, those policies end at age 65.
Okay. Another question that was asked is, what if your job involves driving a vehicle?
That's a very good question, and it's a challenging one to answer. I think part of the reason it's so challenging is if driving a vehicle is intrinsic to your job, it may be very difficult for the employer to accommodate you on that specific issue. That being said, one of the things that Larry mentioned and Susan mentioned was essentially finding your skill sets, determining what you are capable of doing, and trying to see if you can get some types of accommodations or modifications in relation to what it is that you can do. So if you cannot actually drive a vehicle, and that's an important part of your job, sit with your employer to identify other things that you do as part of your job that you could perhaps transition to. There are circumstances where an employer may even be required to create a whole new job description for you, depending on the employer and the needs and accommodations that are required. So again, don't hesitate to express, if you're comfortable doing so, what your restrictions and limitations are, and try to come up with a solution with your employer to finding an alternative position for you in order to preserve your ongoing ability to continue working.
Thank you. I think that the same can be said for a lot of different positions where you've got physicality involved. So there's also another question that was asked about what accommodations could I expect as an occasional teacher with Parkinson's? And I'm assuming they mean that they're a substitute teacher.
So again, an employee, whether they're a permanent employee or occasional employee, they're still entitled to accommodations in their specific position. As teachers, one of the advantages that you have is often teachers are unionized employees. And one of the very important partners in dealing with accommodations is your union. They may be able to assist you in identifying what those accommodations might be. And again, it comes down to speaking with your doctors, figuring out what accommodations you might need, and then in essence, communicating with the employer through your union. There's no difference between accommodating a full-time employee and accommodating an occasional employee or part-time employee. Everyone has the right to be accommodated, and every employer should, accommodate according to the needs that should be met. So my suggestion for you would be consult with your union, try and figure out what has been done in other circumstances for other employees without getting into the details of their conditions. But unions are often great resources for information regarding accommodation, and that's definitely the best place to start.
Thank you. And just a note, in the chat window, we've added a link to a resource on driving with Parkinson's, and we'll also share that in an email that we're going to send out later. So there's one more, it's more of a comment, but I'm going to let you might have something to add to it. Someone commented that they advised their employer while the diagnosis was still being sorted out so that they could have their limitations in relation to their role assessed. The company was able to determine and accommodate their needs, and that enabled them to work full-time for 2 additional years. Looks like we've just got another question. 1 second. What can you do if long-term disability does not cover your financial needs, but your employer is not working with you on an accommodation in a non-unionized environment to maintain your income resources?
That is an interesting question. So to start with, it's important to know and understand that long-term disability actually isn't a complete income replacement. often your long-term disability is a percentage of your income. And what tends to happen when people make a claim for long-term disability and then potentially return back to the workforce in some type of graduated capacity is there may be some form of top-up over and above what you're receiving from your employer. So you might have a situation where you return to the workforce, you're not working at the same capacity as you were, so you're not working on a full-time basis, you're working perhaps on a part-time basis, you're not earning what we call a gainful income, which may have certain sort of thresholds under your specific policy. So let's say, for instance, the gainful threshold is 60%, you're only working and earning 40% of your income. There may be an obligation for, from the long-term disability insurer to top up, but it's only up to the amount of your disability benefit. So there really isn't anything that tops you up over and above your long-term disability. It's kind of the other way around. Your long-term will top you up if your employer is less than or paying you less than your disability benefit in appropriate circumstances. So again, famous lawyer answer, it depends.
Okay, we've got 2 questions. One's a short one and then one might be a little bit longer. One person is asking if there is a mandatory age of retirement.
Not that I am aware of. There used to be, but I think that has changed over time. I don't believe that there's any industry that I can think of, except perhaps something like a pilot that might have a mandatory requirement for retirement. Obviously the importance of that is also, it could enter into sort of the human rights realm. In other words, if you are forced to retire or your employer is sort of making some suggestions that you have to retire, you might be entering into the realm of ageism and discrimination on the basis of age. So that's something that you could look into too, potentially, if that's something that comes up in the context of your employer's interactions with you.
Thank you. And the last question is, can an insurance company train you to do another job? For example, a teacher with Parkinson's gets retrained to be a librarian so that the insurance company doesn't have to continue with long-term disability.
This is a very complicated question, and I will try to explain it as briefly as I can. So in for instance, the workers' compensation world, so WSIB or WSIAD, there is an obligation in that world for retraining. So when an individual suffers a workplace injury and they are unable to work perhaps in their previous occupation, the obligation on the part of the board and the employer is to sort of work towards retraining an individual to potentially do an accommodated job or completely different occupation altogether. In the disability world, there is not that specific obligation. So when your disability insurer talks to you about rehabilitation or retraining or engages a rehabilitation consultant, the goal is not to retrain you into another occupation. In fact, what they're trying to do is they're trying to find a way to, in essence, unfortunately, terminate your disability benefits by forcing you into rehabilitation, which really sort of takes the form of like a graduated return to work program or a work hardening program, something of that nature. And the reason that we see that more frequently than a retraining is because it's very rare to see an insurance company actually engaging in retraining. That being said, I have, in the context of representing individuals in the trades, sometimes seen insurance companies pay for some form of education or retraining program to enable that individual to integrate or begin some type of different occupation or modified occupation. It's not common. I have seen it from time to time. Most of the time, what tends to happen is at what we call the change of definition. So where the disability test changes from an own occupation test, namely whether you're able to perform your own occupation, to what we call the any occupation test. So whether you have the ability to perform any occupation based on your education, training, and experience. If the insurance company feels that the individual has some type of residual transferable skills or skill set that they could parlay or transfer into an alternate occupation, what you tend to see is a termination of disability benefits at that moment in time. We often call that a change of definition termination. So they will terminate because they believe the individual may be able to be retrained, or the individual may have a residual skill set or transferable skills, not because the individual has actually been retrained and returned into an alternate occupation. And those are often cases that we will take on because obviously from our perspective, the individual does not have the ability at that moment in time to return to an alternate occupation. They may over the course of time, but it's not necessarily going to be through the insurance company's auspices. Long answer to a short question.
No, that's great. That's really great information. So at this time, I want to thank everyone who submitted such really great questions. And I'd also like to thank everyone for attending the webinar, and a very, very special thank you to our presenters, Leanne Goldstein, Larry Linton, and Susan Fullerton. In about a week's time, we're going to send everyone an email with a link to a recording of this webinar and any resources that were mentioned here today. Have you gotten your copy of our Every Victory Counts Canadian edition yet? It's available both electronically and in hard copy. Visit our website to get yours today. Parkinson Canada's information and referral associates are available weekdays to answer your questions and to provide you with resources. To reach them, you can dial 1-800-565-3000 or send an email to information.referral@parkinson.ca. Next month's webinar takes place on the afternoon of Wednesday, October 16th, and we'll be exploring stem cells in research. Watch your email inboxes for more details and a registration link. On behalf of all of us at Parkinson Canada, I'd like to thank you for joining us, and I hope you enjoy the rest of your evening.